then we go back to the law, and there's a list. There's actually a list. Here it is. The value of the following property that a spouse owns on the valuation date, that's why I use that term, does not form part of the spouse's net family property. Okay, so remember, the spouse owns it, it's on valuation date, and it's not forming part of the net family property. It's still part of their net worth, but not their net family property. So what can we exclude? So I'm going to go through it and then comment on. So number one is property other than the matrimonial home that was acquired by gift or inheritance from a third person after the date of marriage. So this one is probably the most common one. And there are 3 caveats built into that sentence that I just said. So let's just quickly go through it. Okay, maybe I could even say 4. Okay. Number one is it's property. It's something that exists. It's not the pay down of debt. Okay, so that's really important, right? So like if you have, and this is the prototypical inheritance case, right? So let's say you receive an inheritance during the marriage, you can take that money and put it in different places, right? So number one, you can spend it on a vacation. Well, if you do that, it's gone, it's spent, it's not property that exists on valuation date. So the same thing, you can take that money and put it into the mortgage of a property to pay it down, or a line of credit. And that too, the money has been paid down. And people have said, but that's not fair. There's more equity in the property. Right? But that's not how the law looks at it. It looks at it that you are paying down a debt. Okay, so you want property that is something solid, that is tangible. If you put it into a bank account, it's there, it's sitting there. Then that's good. If you put it into a car, and we're going to go through that shortly. But the point though is that it exists. Very important. It exists. Okay, got it. Okay. The next one I'm actually going to skip because it's the people get very upset about it. So I'm going to come back to it. Okay. The next caveat is that it's a gift or inheritance from a third party. Okay. So many people get confused and they say, well, I received, this diamond ring from, during the marriage, it was my birthday and I got this ring from my spouse and I'm excluding it. It's a gift, right? But it has to be a third person. 3's a crowd, right? Like it's not from either of the spouses. It has to be from outside of the relationship. And it makes sense, by the way, why it's outside of the relationship, because we're excluding things that are not from the relationship. It's not an equitable sharing of the growth of the marriage, right? This is something coming from the outside into having nothing to do with like effort, that parties do during the marriage. Okay, so we need property. It's got to be from a third party. And now we have to look at this. This is very important also. It's going to be related to our subsequent video that we're going to do, but it has to be after the date of marriage. Okay, so if you receive an inheritance on the day before you got married and it's sitting in a bank account, that is not excluded property. If that money sits there and grows by interest, interest income or whatever, that growth will be completely included in the calculation. There's going to be a date of marriage value and there's going to be a valuation date value, and that's going to be included in your net family property. That's on the day before you got married. If you received it on the day after marriage, then you can exclude it. Now, paragraph 2 deals with the growth, the income. But the point is, though, that it has to be received after the date of marriage. It's a very important distinction that people have litigated over, especially on inheritances where a person could pass away, unfortunately, before the marriage, but you only receive the inheritance after. So which date is it? Is it the date of death or is it the date of receipt? So people have litigated. The short answer is it's the date of death, because that's when the right vested into the person. So,
Oh my goodness. Okay.
okay, so that if you consider this concept of excluding property from the calculation as an exception,
Yeah.
right? It's an exception. We're including everything in this property calculation, but we have this list here of things that are excluded, and therefore it's kind of an exception to the calculation. Well, there's an exception to the exception. Just to
As
make life
usual.
complicated. And that's over here, other than a matrimonial home.
Right.
Right. So let's say you receive that inheritance in middle of the marriage, and let's say the inheritance was a property, and you move into it, and it becomes what's known as a matrimonial home.
Yes.
Okay. So, and this happens. So we're not even dealing with the pay down of the mortgage issue, right? That's kind of a separate issue.
Yeah.
But let's say the money goes into a matrimonial home, or a new property is purchased and the down payment comes from an inheritance,
Yes.
and that is then a matrimonial home. So this is the exception to the exception, even though that property exists on the date of date of separation, and it was acquired by gift or inheritance from a third party after the date of marriage, and it's truly his property, right? Like
Yeah.
all those other necessities are there. Just because it's inside something called quote unquote matrimonial home, you lose the excluded property. We call it, you lose it, you lose the exclusion.
Okay.
So the problem that most people encounter in this situation is, number one, they don't know that, right? Like, it's like, nobody told me. That's sad.
Yes.
It actually is extremely sad, especially when people are relying on it. The second problem is that there can be multiple matrimonial homes in law. And this is a very contentious point. There's lots of court decisions over it as to what constitutes a matrimonial home. But the very prototypical case is the family cottage that you
Yes.
receive by inheritance, right? And it could be that you receive it by inheritance even with siblings, like you're a co-owner of a
Yeah.
cottage, but you use it to the extent that it's considered a matrimonial home. That is, separate from this video, like all those court decisions on that issue. But the
Wow.
point though is that many people get also shocked, and people litigate over this, that the cottage value would be included anyway in the net family property, but the exclusion is lost because it's considered a matrimonial home. Okay, so that was line item number one of excluded property,
Okay.
right? And it makes sense. You're receiving something from a third party
Yeah.
that is during the marriage, and is not really part of it's not the fruits of the marriage. It's
Right.
something that, it's landed from outer space kind of thing. And so it makes sense in equity, in the law of fairness, that it should not be shared between the spouses. However, you can lose that exclusion. Okay, let's just quickly go through the rest of them, because
Okay.
that one is the prototypical one that usually people find out about and they care about.
Hmm.
And then we're going to go through a couple of examples. Okay, so let's just go through the rest.
Okay.
So this one is important, especially when there's cash.
Yeah.
So income from property, that's referred to in paragraph 1. So you receive a gift or inheritance, it's
Right.
money, and you want to also and it grows by
Right.
by interest. So can you exclude that? That's a good question just in
Mhm.
life. Can you exclude that? Because there's principal and there's income, and so maybe they're separate. And the answer is they are separate, but you can exclude income if the donor or testator expressly stated that it should be excluded from the spouse's net family property. Okay, so it requires an express statement. And what's interesting is that I think there's case law on whether expressly means that it has to be in writing or not. But as a default, if you look at any will that is created in Ontario, like standard language in the back includes that I want this inheritance to be excluded, but also the income to be excluded. So just to be very clear, you don't need that language for the exclusion for number one. For the principal that you receive, it's excluded just based on the fact that you receive it, right? That it qualifies under number one. It's the income that needs to be expressly stated to be excluded. Okay, and so again, on a death inheritance, that is going to usually be already factored in. Certainly in Ontario, a foreign will may be problematic. Where this usually comes up, though, is when a spouse receives a gift from a parent, usually or an extended family, during their lifetime. So that is a gift, right? It's a gift. It's excluded up here, but many people forget that they need to expressly exclude the income. Sometimes people do, if they go to an estate lawyer, they'll get that advice to make a declaration that includes that language. Okay, let's keep going.
Oh, can I just ask a quick question about this gift? The gift, because I in a way with the will is easier, right? Or an inheritance is easier because there is the will. But I think generally when people give gifts, they're not thinking, oh, I now also have to write a little note. Like, would a note be enough? Do you think, or an affidavit? Like, I mean, I think it's just a note, right?
A note is enough.
Okay.
It just has to be expressly stated.
Okay. Yeah.
Okay. And again, I'm sure there's case law, and I don't have the answer off the tip of my fingers as to whether or not a verbal expression is enough.
Interesting.
I'm not gonna speculate.
Right. Yeah. Sounds good. Okay.
Okay. So a couple of other items that you may receive during a marriage is also to be excluded. Okay, because it's also falling from outer space and it doesn't make up part of the fruits of the marriage. And so one of those is proceeds or a right of proceeds to a policy of life insurance. Property other than a matrimonial home into which the property referred in paragraph 1 to 4 can be traced, and that we're going to talk about number 5 separately. That's our next line item. Property that spouses have agreed by a domestic contract is not to be included. So there you go. It's funny. It actually says not to be included. So if you sign a marriage contract or a cohabitation agreement that turns into a marriage contract that says this item is excluded, then obviously that's captured by this section over here. And then lastly, and this is funny that this is here, but Canada Pension Plan credits, which are divisible, just like an equalization calculation of net family property, that it's just not done under the Family Law Act. So it's excluded under the Family Law Act. We don't usually even put it into our financial statements at all, which is actually kind of interesting anomaly. But if I were to click under Canada Pension Plan, there is a whole section about dividing pension credits. Maybe that could be another video. But the point, though, is that it's separate. It's not part of our calculation that's going to be included in your financial statement. Okay, so let's actually talk about this concept of tracing and how that all works. Okay.